Fraud is a constant threat to your notary commission. You need a shield. The book by Derek Spruill, Notary Fraud Shield, could provide you with some advice. Learn real-world tactics, notice red flags, and develop refusal strategies to protect your notary commission. Buy your copy of Notary Fraud Shield by Derek Spruill from any online bookstore, Amazon.com, Barnes & Noble Bookstore, booksofmillion.com, bookshop.org, Mobile Notary by DerekSpruill.com, or download from Kindle to obtain your essential notary book to help with all your notarization starting today.
Welcome back to Notary Knowledge, everybody. We are so glad you are tuning in today. You know, if you picture a notary public right now, you probably just imagine a human rubber stamp.
Right. Yeah, just sitting at a desk.
Exactly. You sit across a desk at a bank or like maybe a real estate office. You sign a thick stack of paperwork, and someone just hits the page with a little ink pad. It feels like a desk accessory, honestly.
It really does.
Just a minor bureaucratic hurdle you have to clear before you can, finally get the keys to your new house.
And, I mean, it is so easy to dismiss that ink stamp as just some leftover relic from the 19th century. We live in this era of digital signatures and, biometric logins. So a physical stamp on a piece of paper just feels kind of quaint.
But the reality of that stamp is, well, it's anything but quaint. Today, we're doing a full breakdown of the source material, specifically looking at the laws governing Indiana notaries.
The Hoosier State.
Yep, pulling straight from Title 33, Article 42 of the Indiana Code, some recent updates from the Secretary of State, and even local county recording rules. And the picture that emerges here is entirely different from that desk accessory idea.
Oh, completely.
A notary isn't a rubber stamp. They are literally the state's frontline defense, like a highly regulated, bonded gatekeeper standing between our everyday legal agreements and just absolute chaos.
Yeah, the integrity of the entire legal and financial system relies heavily on that one single individual verifying identity and willingness. I mean, if you can't trust the signature on a property deed or a last will and testament or some massive corporate contract, the whole foundational system of legal trust just breaks down.
Which is exactly why this matters to you, listening right now.
Mm-hmm.
We know a lot of you out there are experienced, high-level professionals. You already know the basics.
Right. You're in the trenches.
Exactly. Yeah. But maybe you frequently need documents authenticated for your business, or you're just wildly curious about these invisible safeguards that hold our society together. Understanding these specific Indiana rules is crucial because a single, seemingly minor misstep can invalidate a multi-million-dollar transaction.
Oh, yeah, or open you up to massive personal liability.
Right. So let's just get into it. And to understand the sheer weight of a notary's signature, we really have to look at the gauntlet required just to obtain that stamp.
Yeah, and in Indiana, the foundation starts with some pretty strict qualifications. Obviously, you must be at least 18 years old, a citizen or permanent legal resident of the U.S., and you have to clear an Indiana State Police limited criminal history check.
Which makes sense.
Right. Any convictions involving deceit, dishonesty, or fraud, that will disqualify you immediately.
Which is, like I said, completely logical for a fraud deterrent role. But there is this fascinating geographical loophole in these requirements that caught my eye.
Oh, the residency thing.
Yes. You do not actually have to live in Indiana to be an Indiana notary.
Yeah, it's true. Indiana law allows out-of-state residents to hold a commission, provided they are, quote, primarily employed in the state of Indiana.
So wait, if you sleep across the border in, say, Illinois or Ohio,
Yep.
but you commute to an office in Indianapolis or Gary, you can absolutely become an Indiana notary.
You can. The mechanism for this is basically an employer consent form. It's just a formal letter on company letterhead proving your primary employment is, anchored in the state.
So the state is essentially saying, we don't really care where you sleep, we just care where you work.
Pretty much.
But there is a catch to that loophole, right?
Right.
If you lose that Indiana-based job.
Oh, your commission immediately becomes invalid. It evaporates the exact moment your employment terminates.
Wow.
But assuming you keep your job or you are a regular Indiana resident, the term of the commission itself is uniquely long. In many states, a notary commission is good for maybe 4 years.
Right.
Indiana commissions you for a massive 8-year term.
8 years. That is a lifetime in the legal and technological world. I mean, think about how much the internet alone has changed in the last 8 years.
Exactly. And because of that, to keep that commission alive, Indiana imposes a strict continuing education requirement. Every 2 years, you have to pay a $50 fee and take a mandatory state course.
Okay, that seems standard.
It is, but this is where the state sets a trap that catches a surprising number of people completely off guard. There is absolute zero tolerance for missing that continuing education deadline.
Wait, zero tolerance? Like, if I miss the deadline by a day, I can't just pay a late fee and take the course over the weekend.
Nope. If you miss the deadline by a single second, your commission permanently expires.
You're kidding.
I'm not. It doesn't get suspended, it dies. You have to start the entire application process completely over. I'm talking a new background check, a new exam, new application fees, all of it.
That is brutal.
Yeah.
Okay, I want to look closely at the financial requirements here, too, because when I was reading through the Indiana Code, the bond rules genuinely confused me.
Yeah, bonds confuse a lot of people.
Right, so to become a notary, you have to purchase a $25,000 corporate surety bond. The state recently banned those freehold bonds, where you basically pledge your personal real estate as collateral.
Right, freehold is out.
So it must be a corporate surety bond.
Yeah.
But if I am paying for a $25,000 bond, it doesn't even cover my own mistakes.
Yeah, that is probably the single most dangerous misconception about holding a commission. People hear, oh, I have a $25,000 bond, and they just assume they have $25,000 worth of insurance if they screw up.
Right, that's what I would think.
But the bond strictly protects the public from you.
So if I fail to properly check someone's ID, and they use a fake driver's license to, I don't know, fraudulently transfer the title of a house.
The victim goes after your bond. The victim makes a claim against it, and the surety company will pay out up to $25,000 to make that victim whole.
Okay.
But here is the kicker. A surety bond is not insurance. It is basically a line of credit guaranteeing your performance. Oh, yes. The surety company will turn right around, take you to court, and sue you, the notary, to recoup every single penny of that $25 grand.
Wow. So the bond is really just the state making sure the public gets a guaranteed, fast payout. But I am still personally on the hook for the full amount.
Exactly. Which is why errors and omissions insurance, E&O insurance, is practically a necessity in this field, even though the state of Indiana does not legally require it.
Okay, that makes sense.
Yeah, the bond protects the public, but E&O insurance actually protects the notary's personal bank account from unintentional mistakes.
All right, I think that's a perfect spot to pause. We are going to take a quick commercial break, but don't go anywhere.
Yeah, we'll be right back.
And hey, while we're on break, if you want to really level up your expertise, you should absolutely grab the Notary Knowledge books by Derek Spruill. They are fantastic resources.
Absolutely. And you guys should also visit the Notary Knowledge website and be sure to check out our video podcast, No Notary, with Eddie Montes Travis, and definitely watch Marylyn's 90 Seconds of Notary Shorts. So much good stuff there.
Tons of great resources for you guys. All right, we'll be right back.
See you in a minute.
Okay, and we are back. So we've established that once you possess this highly bonded 8-year authority, you are carrying around a massive amount of liability.
Oh, a ton of liability.
Because of that, the state places severe restrictions on exactly how and for whom you can use that stamp. The ethical prohibitions are incredibly strict. Like, for starters, you obviously cannot notarize any document for yourself or for your spouse.
Right. The law flatly states that performing a notarial act for yourself or your spouse renders the act void, but the prohibition actually goes deeper than that.
How so?
You cannot notarize any transaction where you or your spouse receives a direct beneficial interest.
Oh.
So if your spouse is gaining financially from a business contract, you cannot act as the impartial witness to that contract.
Okay, but what about other family members? Like, if my brother comes to me with mortgage documents for his new house, am I allowed to notarize those?
So this enters the dangerous gray area of consanguinity, meaning blood relatives.
Right.
Under the strict letter of Indiana law, it is not explicitly illegal to notarize for your brother, your parents, or your children, provided you aren't receiving a direct beneficial interest.
So because I'm not getting money from my brother's house, I'm technically in the clear.
Technically. But from a practical legal standpoint, it is a massive risk due to that beneficial interest test.
How does that actually play out in the real world, though? Say there is a dispute over that property down the line.
Well, if that document ends up in litigation, the opposing lawyer is going to pull the deed, look at the notary stamp, and say to the judge, Your Honor, this contract was supposedly witnessed impartially, but the notary is the signer's own brother. We allege undue influence and fraud.
Oh, wow. Yeah, I can see that.
Right. The document invites immediate, intense legal scrutiny. So even if it is technically legal to stamp your brother's paperwork, it might be the exact reason the document gets thrown out of court.
You are basically handing the opposing legal counsel a loaded weapon.
Pretty much.
And the rules are even more protective when we look at vulnerable populations. A notary absolutely cannot take an acknowledgement from someone who has been adjudged mentally incompetent or is under guardianship.
Correct.
But what if a signer is sitting in front of you, they're completely mentally competent, but they are blind?
The state requires the notary to act as a protective barrier here. If the signer's blind, the notary must read the entire document to them first.
The whole thing.
The whole thing. You cannot simply guide their hand to the signature line. And similarly, if the signer does not speak English, the document must be translated into a language they understand so they comprehend the nature and effect of the transaction.
That makes total sense. And you know, that protective barrier concept is also why the state cracks down so hard on notarial fraud.
Oh, yeah. That's a huge issue.
Engaging in notario publico deception in Indiana is a Class A misdemeanor.
It is, and it's really a systemic issue born out of language and cultural differences. Because in many Latin American countries, a notario publico is actually a highly trained, elite lawyer who can draft legal documents, represent clients, and give legal advice.
It's a prestigious legal title over there.
Exactly. But in the United States, as we know, a notary public just verifies identity and willingness to sign. So predators exploit that translation.
Right. Unscrupulous individuals will set up shop in Spanish-speaking communities, hang a sign that says Notario Publico, and deliberately imply that they are lawyers.
Yeah, and then they charge exorbitant fees for legal advice they are entirely unqualified to give. They often end up destroying people's immigration cases in the process because they filed the wrong paperwork.
It's heartbreaking. So to stop this, Indiana mandates that any notary who is not a licensed attorney and who advertises their services in any language must include a highly visible disclaimer.
Yep. It has to say, I am not an attorney licensed to practice law in Indiana, and I may not give legal advice or accept fees for legal advice.
And if they violate that or engage in notario deception, the penalty is permanent, isn't it?
It is. A judge will revoke their commission, and they receive a lifetime ban from ever being a notary in Indiana again.
Wow. Now, I want to pivot a bit because if you are listening to this and thinking, when I just notarize standard forms at my office, this doesn't really apply to me, I want you to consider this scenario.
This is a classic one.
Right. Your boss, the person who signs your paychecks and who probably paid for your $25,000 bond and your ink stamp, walks into your office, drops a stack of documents on your desk and says, hey, the client had to leave in a hurry, but I saw them sign these. Just stamp them so we can close the deal.
I mean, the pressure in that moment is immense. It's like what we saw in prior shows, with Fiona in Idaho dealing with abuse of power, or Patty in D.C. with those rushed petitions. But the legal reality in Indiana is absolute. You have to say no, even if the employer paid for every single part of your commission. That commission belongs entirely to you, the individual notary.
You can't just use the defense, my boss forced me to do it.
No court cares about office politics. Yielding to an employer's pressure to notarize outside the physical presence of the signer constitutes official misconduct.
Period.
Period. Notarizing a signature when the person isn't in front of you renders the document void, strips you of your commission, and opens you up to personal, civil, and criminal liability. The physical presence of the signer is the absolute, non-negotiable core of the traditional notarial act.
Which brings us to the biggest shift in this entire landscape, because technology has completely redefined what physical presence actually means.
Oh, it really has.
In July of 2020, Indiana overhauled its laws to authorize remote online notarization, or ON.
Right. RON allows the signer to appear in real time via a secure, state-approved audiovisual platform. They no longer have to breathe the same air as the notary.
But I'm looking at the requirements, and this isn't just jumping on a FaceTime call and holding your driver's license up to the webcam, right?
Oh, not at all. It requires a serious upgrade to your commission. You have to pay a separate $100 fee, pass a distinct remote notary exam, and contract with a tech vendor explicitly approved by the Secretary of State.
Okay, so it's heavily regulated software.
Extremely. These platforms are required to use advanced identity proofing, specifically credential analysis and dynamic knowledge-based authentication.
Hold on, let's break down that jargon for a second. What exactly is dynamic knowledge-based authentication?
Right, so think of it as a quiz that only you can pass, generated in real time by a computer scrubbing your public and financial record.
Oh, like when it asks about past addresses.
Exactly. The software might pull from your credit history and ask, which of these 4 streets did you live on in 2012? Or which of these banks held your car loan in 2018? A hacker with your stolen physical ID cards just wouldn't know those answers.
Because they're so specific. The software basically verifies the identity before the video call even connects.
Yeah. And because this requires so much more technological overhead, the state changes the fee structure. A standard physical in-person notarization in Indiana is strictly capped at $10 per act. But for a remote online notarization, you can bill up to $25 per act.
That makes sense.
But that increased fee brings an incredible increase in record keeping. Under the 10-year rule, a remote notary must keep a secure, password-protected electronic journal of every remote act and a full audiovisual recording of the entire session for at least 10 years.
Wait, 10 years? That is an enormous amount of video data for one person to securely store.
It is, but it ties directly into the statutes of limitations for fraud and property disputes.
Oh, I see.
Yeah, if someone challenges a real estate transfer 7 years after the fact, claiming their signature was forged, the court needs to see the proof. The notary has to be able to retrieve that video file and show the judge the exact moment the person was authenticated and signed the document.
So you are basically a walking, highly secured legal archive.
You are.
But here's the question about remote notarization that really jumps out at me.
Okay, what is it?
If this is all happening on the internet, and the signer can be sitting in a coffee shop in Tokyo, why does the notary legally have to be physically sitting inside the borders of Indiana? I mean, the internet is borderless.
That is a great question. It comes down to the jurisdictional boundaries of state sovereignty, and Indiana Notary Public is commissioned by the governor of Indiana.
Right.
So their legal authority is inherently derived from and tethered to the sovereign borders of the state.
So they project Indiana's legal authority out into the internet, but the projector itself has to be physically plugged into an outlet in Indiana.
Exactly. I love that analogy. And if you unplug that projector and move it to a coffee shop in Chicago, the screen just goes blank. You have zero legal authority.
Wow.
Yeah. If an Indiana notary crosses the border into Illinois and performs a remote notarization from their laptop, the act is completely invalid.
It is such a wild mix of 21st century cloud technology restricted by 19th century geographical borders.
It really is.
Now let's talk about the bureaucracy for a second. Because even if you navigate the $25,000 bond, the ethical minefields and the complex digital platforms perfectly,
I know where this is going.
the document can still hit a brick wall. A flawlessly executed notarization will be flatly rejected if it doesn't meet incredibly specific bureaucratic aesthetics at the county level.
Oh man, the county recorder is basically the final boss of this process. The notary might have verified the identity perfectly, but if the physical document violates local recording rules, it is not going into the public record.
Let's look at Porter County as a prime example, sort of a little Hoosier Handbook breakdown, some Indiana trivia for you.
Oh, the margin rules.
Yes. If you submit a document to the Porter County recorder, it will be rejected if it does not meet the strict 2-inch margin rule. The first and last pages must have a minimum 2-inch margin on the top and bottom and a 1/2-inch margin on the sides.
And this is statutory. The recorder's office physically needs that specific 2-inch blank space to affix their own official recording stamps and barcode stickers. If your text bleeds into that space even a little bit, they kick it back.
Imagine being a real estate agent trying to close a multi-million-dollar commercial property, and the entire deal just derails on a Friday afternoon because someone used a 1.5-inch margin on page 1.
It happened all the time, just like Lucas in Oregon dealing with that travel fee mess we talked about before. It's just administrative friction.
Exactly. And there are other strict mandates, too. Documents cannot contain a Social Security number unless explicitly required by law. The preparer must include a sworn affirmation statement that they have taken reasonable care to redact any SSN.
Right, and every document also needs a prepared by statement explicitly naming the person who drafted the instrument.
And speaking of hyper-specific laws, this brings up a really interesting piece of recent legislation, House Bill 1056, which was signed in 2021.
Oh, right, the emergency fix.
Yeah, this was an emergency fix for a legislative typo that caused absolute chaos in the real estate market.
Yeah, back in July 2020, a new state law accidentally created this redundant requirement. The language essentially stated that for a document to be recorded, it needed both a notarial acknowledgement from the signer, and a separate proof from a witness.
Wait, so you basically had to notarize things twice?
Basically, it was an unintentional error in the bill's wording. Someone replaced an or with an and.
You're kidding. One word.
One word. And since recorders have to follow the exact letter of the law, thousands of standard documents were suddenly non-compliant. HB 1056 had to be rushed through the State House to fix it, clarifying that you only need either a notarial acknowledgement or a witness proof.
Thank goodness.
Yeah, and it even provided retroactive protection for documents recorded during the months that the bad law was active, so people wouldn't, lose their homes over a typo.
That is wild. The rules are constantly evolving to remove friction, though. Just this past summer, as of July 1st, 2024, the state updated the physical requirements for the notary stamp itself.
Yeah, the state removed the requirement that the actual word seal has to appear on the physical stamp.
Wait, so the seal doesn't need to say seal?
No, it doesn't. I mean, it still absolutely must contain the notary's exact name, the words Notary Public, State of Indiana, the commission number, and the expiration date. But the word seal is no longer statutorily required.
That's fascinating.
If you're a notary ordering your supplies, or maybe a lawyer reviewing a 2025 document for compliance, knowing that nuance is just critical to verifying the document's validity.
I think the next time you as a listener sit across a desk and watch someone press a simple ink stamp onto a car title or a power of attorney, you're going to view that interaction completely differently.
I would hope so.
You aren't just looking at a piece of rubber and some ink. You are looking at the culmination of an 8-year commission, a $25,000 surety bond, 10-year video retention rules, and just a labyrinth of ethical landmines.
Exactly. You are witnessing a highly trained public official executing a process designed to protect the very foundation of our property and legal rights.
It truly is the invisible weight holding the system together. But before we wrap up, I want to leave you with a final thought to mull over on your own.
Oh, let's hear it.
We've seen how Indiana has rapidly evolved from ink and paper to authorizing video feeds and dynamic data scrubbing across the planet, right?
Right.
If state law now allows a notary to verify the signature of a total stranger sitting in a coffee shop on the other side of the globe using digital platforms and algorithms, how long will it be until artificial intelligence and biometric blockchain ledgers replace the need for a state-commissioned human witness entirely?
Oh, wow.
Will the impartial witness of the future simply be a piece of code that can never be bribed or pressured by a boss? It's definitely something to think about the next time you sign your name on the dotted line.
That is a great question to end on. And hey, for our listeners, be sure to email your questions to Derek at derekspruill.com. We will try to answer them as soon as possible at the end of our shows.
Absolutely. Big thanks to our team. Executive producer Derek Spruill, lead writer Marylyn Lee Trotter, graphics by Eddie Montes Travis, music by Thomas Bynum, and produced by Magnificent Works Business Solutions.
Don't just be listeners of the knowledge, be doers of the knowledge.
This is Notary Knowledge. Until next time.
Are you truly protected as a notary public? Navigate the complex legal framework with confidence using Notary Law and Liability by Derek Spruill. This essential guide provides a deep dive into state regulations, ensuring you stay compliant across jurisdictions. Learn how to properly use errors and omissions insurance and master the critical boundaries to strictly avoid the unauthorized practice of law. Protect yourself, your commission, and your business. Get your copy of Notary Law and Liability by Derek Spruill on Amazon.